definition of royalty and allocation rules under DTAA. Friends, royalty is a very interesting topic as well as it is a very wide topic. Therefore, university has kept so many sessions on the topic royalty for all of you. Tax is a very interesting subject. Recently in the budget 2024, our Honorable Finance Minister announced that she will be coming out with a new direct tax code in coming 6 months. Let's see that it would be a simple tax, not like a goods and services tax. Royalty is one of the intellectual property right, that is IPR. Therefore, we have to make ourselves aware about the IPR laws as well as intellectual property laws. Taxability of royalty is a very wide concept. There is a lot of developments in a particular space. Therefore, extensive litigation. Litigation at every level. We will see some case laws where once the court has decided that it would be classified as royalty, but similarly on the same ground the another court said that it is not treated as royalty. Therefore, extensive litigation. So much of litigation is involved in royalty. Characterization of service as a royalty is very important. Let's broadly understand the concept of royalty. Before going to definition of royalty, what is a broad concept of royalty I would like to take you all through. When a foreign company does not have a permanent establishment in India, then royalty will be taxed on gross basis. What do you mean by gross basis? Whatever amount we are paying as a royalty. Suppose a resident Indian in India is paying a royalty amount of 10,000 to Mr. X in US. That gross amount would be taken as a royalty and it gets taxable and TDS is deducted under section 195. But if permanent establishment of foreign company is situated in India, in that case the taxability is dependent on net basis, that is after expenses allowances from the gross amount of income, tax is being charged. Royalty tax rate given under section 115A of the Income Tax Act is 20%. Previously friends, it was 10%, which was very low. Then government realized that royalty income is increasing and India is getting more of royalty income, so we must tax it in India. Non-residents are also earning a huge amount of income in the form of royalty. If we use income tax rate, in that case we have to add surcharge and applicable cess. It is about Income Tax Act. If we will talk about double taxation avoidance agreement, so in double taxation avoidance agreement we have to refer Article 12 or Article 13 of the concerned DTAA. Some articles cover Article 12, some articles cover Article 13. It has tax rate varying from 5% to 20%. Then in Income Tax Act we have section 90 subsection 2, which is known as a beneficial clause. This clause is added so that there would not be double taxation, plus whatever rate given under Income Tax Act or DTAA rate, whichever is beneficial to the SSE, would be made applicable. Then if you will see, there are compliance requirements which are part of the Act. 90 subsection 2, a foreign company or foreign recipient can take benefit of DTAA if he follows certain conditions. An Act would apply only if it is beneficial to the SSE. Section 90 subsection 4, it talks about TRC, Tax Residency Certificate. It is a very important certificate. It is to be provided to avail the benefit of DTAA. If the SSE does not own tax residency certificate, then he is not eligible to claim the benefit of DTAA. Then section 195. Section 195 is very important section which talks about tax deduction when payment is being made to non-resident at the prescribed rate under the Income Tax Act or DTAA, whichever is beneficial to the SSC. Then a very important section, section 206AA. What it says that if SSC does not submit PAN, then higher tax rate, let's say 20%, is applicable. Now friends, the rate of royalty under section 115A is 20%. So per se, section 206AA has no relevance. Now this section seems to be diluted. Then the most important section which comes is 40AIA, which says that there would be 100% disallowances of expenses when withholding tax has not been done, and interest and penalty should be extra charged in that case. Now we will understand what is the broad scheme of taxation under Income Tax Act. Every person is liable to pay income tax in respect of his total income. Total income computation is very important in accordance with the provision of Income Tax Act 1961. For determination of taxability, the Act in general follows a combination of source and residence rules. In India, we all know that we mainly follow the residence rule, but at some points we have to follow source rule as well. Accordingly, as a starting point, it is essential to examine the residential status of the SSC. The scheme for determination of same is provided under section 6 of the Income Tax Act. So friends, we will say that section 4 of the Act is a charging section which allows us to charge income tax. Section 5 talks about income deemed to be received in India or income received accrues arises in India. There are different tests laid down for determining the residential status of an individual, companies, etc. The same would largely depend on factors such as duration of stay in India for individuals, country of incorporation coupled with existence of control and management for the companies. Section 5 talks about income accrues or deemed to be accrue in India. First we have to check this, and if it fits in section 5, then we don't have to move to section 9. Section 9 comes into play when the income is classified as deemed to accrue or arise in India. Section 9 of the Act, which is an unambiguous extension of source rule, deals with the incomes which are deemed to accrue or arise in India. Clearly, therefore, an income in order to be taxed in India under section 9 need not accrue or arise in India. Friends, this is a very important concept, that if any income is being classified under section 9, so it must not be accrued or arise in India, but it must be deemed to accrue or arise in India. Deeming fiction is very important in this case. One of the view is that the deeming provisions governing the scope of total income that is deemed to accrue or arise in India should be examined only if the income is deemed to accrue or arise, if the income is not actually accruing or arising. This is based on premise that a fiction is not needed to create a situation which exists in reality. Now coming to meaning of royalty. This was the basic understanding of the income tax law and the taxability of royalty. But what is meant by royalty? Royalty definition is nowhere given as per the Income Tax Act. Therefore, we have to refer certain other laws as well as certain commentaries to understand what is the meaning of royalty. Until we understood what is royalty, we cannot tax it properly. Royalty refers to a contractual payment. So first important thing is there is a contractual payment. There is a contract between licensor and licensee. The two parties in case of royalty is being termed as licensor and the another party is termed as licensee. So the royalty refers to a contractual payment by a person for the use of assets belonging to another person. The payment includes royalty for use of intangible assets such as copyrights, trademarks, or franchisee model agreements. We will deal in detail copyrights, trademarks, franchisee, patents, etc. know-how. Royalty is also paid for the use of natural resources such as mining leases. Royalty agreements generally give limited right to use such assets or resources. Now friends, here we have to see that whether full patent or trademark is transferred means whether there is an outright sale. If there is an outright sale, it will be classified under head capital gains. But if it is being given for use or right to use, whose definition also is very important, so in that case we have to refer it as a royalty, and on that royalty tax is being levied in India. Now the two parties of agreement are known as licensor and licensee. Who is a licensor? The party granting right to use an asset or resource. Suppose Mr. X holds a patent. He has made a product and he got it patented. He is the licensor. Now I asked him that I want to sell this product. Could you please share the formula of your product, share the process of the product? So the licensee says yes, but I will take certain royalty for the same, certain percentage of royalty. So the person who is accepting the right to use and pay for the right in license is termed as licensee. Now royalty agreement. Then the important aspect which comes is that there is an agreement. Without an agreement or a contract, everything is void. So licensor as well as licensee enters into an agreement which is termed as a royalty agreement. It specifies the terms and condition of grant of right to use under the agreement. Terms and conditions are very important whenever any person is granting. Suppose that I will take license fees on the basis of percentage of sales made by you. Then the agreement also mentions how much consideration the person licensor will take for right to use and how much duration, whether the license is given for 6 months, 1 year, 2 years, etc. From a tax perspective, royalty agreement should always be at arm's length price. Here transfer pricing provisions also come into play. That royalty agreement should always be made at arm's length price. The taxation depends on laws of the country. Every country have their own laws. They tax royalty on the basis of their laws. Now, royalty is a passive income stream providing benefit to people who create intangible assets or work of art. Then we can say like music. Those who are musicians, they can also sell their rights or they can allow rights, music rights, cinema rights, and author often grant the right of use, that is copyrighted material, and earn income. Royalty agreement includes license agreements to use assets or properties in return for a payment. In the case of non-renewable energy resources, royalties are generally paid to government of the state. An example of royalty paid to the state is mining royalty. Generally, the state holds the mining rights, so they give mining rights to the licensee and charge against that. Also, in the case of extraction of oil and natural gas, royalties are paid to the state. In respect of television channels, royalties are paid by television channels to satellite companies. We can say that royalty agreement specifies the terms and conditions of grant of right to use under the agreement. The agreement also mentions the consideration for the right to use and the duration. From a tax perspective, royalty agreement should be on arm's length basis, and the taxation, however, depends on the laws of each country. Now friends, we will refer certain definition like Encyclopedia Britannica 1972 edition. What it says? It says is the royalty means the payment made to the owners of certain types of rights. We are making payment to the owner who is holding the patent, trademark or copyright by those who are permitted by the owners to exercise those rights, means the licensee. Owners permit licensee to use the right. The rights concerned are literary, that is related to literature. It may be concerned with music, it may be concerned with art, it may be concerned with design, it may be concerned with mineral deposits, natural or oil and gas. As to inventions, like it includes inventions as well. A royalty may be said to be a compensation paid under a license. Means a compensation is being paid under a license granted by the owner of the patent, that is the licensor, to another person, licensee, who wish to make use of the invention or the subject of the patent. The patent remains the property of licensor. This is very important point. Like here, whenever a royalty is being paid, the licensor is not completely transferring the patent or trademark to the licensee. The licensor is only giving use or right to use, and terms and conditions are being satisfied. Now, a license can be exclusive or non-exclusive. It depends on the licensor. A license may be exclusive, in which case the patent owner precludes himself from granting licenses to third parties. Exclusive means the patent owner is not ready to give license to the third parties. Non-exclusive, in which case the patent owner may grant licenses to as many persons as he wishes. So, non-exclusive means the patent owner can grant the license to as many persons as he thinks fit. Then, second definition. Wharton's Law Lexicon defines royalty as. It defines royalty as payment to a patentee by agreement on every article made according to the patent, or to an author by a publisher on every copy of the book sold, or to the owner of mineral for rights of working the same on every ton or other weight raised. It simply says that if any article is being written and on that article a royalty is being paid, or a patent is there, that patent use royalty is being paid, or for mineral any right is given and royalty is being paid. Law Lexicon further by Ramanathan Iyer, it specifies that royalty would mean percentages or dues payable to landowners for mining rights. Here it says that royalties would be paid on the basis of percentage, certain percentage, like 5% of sale or 1% of some consideration. Royalty would mean sum paid for use of patent. It says that if you are using patent of licensor, whatever amount you are paying is termed as royalty. Then percentages paid by an author by a publisher on the sale of the book. Whenever an author has written book, the author has given rights to the publisher to publish the book and pay certain percentage of royalty on the basis of books sold by the publisher. Then Wikipedia. Wikipedia defines royalty as royalty. Sometimes we can say royalties are running royalties. Running royalties means continuously we are making payment. or private sector taxes are wage-based payments made by one party. They are terming it as a labor charge, the licensee, and another the licensor, for ongoing use of the asset. The licensee is continuously using the asset, sometimes an intellectual property. Royalties are typically agreed upon as a percentage of gross or net revenues derived from use of an asset or fixed price per unit sold of an item as such. But there are also other modes and metrics of compensation. It may be in the long term form also. Suppose 1 lakh rupees paid, 100 crores is being paid. So royalty can be in per unit sold form, or it can be in any other mode which is being determined by licensor and licensee. Then Black Law Dictionary 11th edition defines royalty as in respect of intellectual property. Intellectual property includes patents, copyright, and know-how, etc. Royalty is defined as a payment in addition to or in place of an upfront payment. Upfront means advance payment, which is being made to an author. An advance payment is being made to an author or inventor for each copy of a work or article sold under a copyright or a patent. Royalties are often paid per item made, used, or sold as the time elapsed. These were the definitions which are given by the authors. Like we refer some of the definitions which we discussed above. Now friends, most important section which covers royalty income is section 9 of the Income Tax Act 1961. Section 9(1) subsection 6. It is being termed as 9(1)(vi), royalty income. The following income shall be deemed to accrue or arise in India. Income by way of royalty payable by the government. So the first point is the payment is made by the government to non-resident. Government may be state government, government may be central government. If government receiver is receiving amount by way of royalty, we will learn the definition also. What is meaning of royalty? If payment is within the meaning defined under royalty under the Act, taxpayer is a government, so the taxpayer have to deduct TDS under section 195 of the Act. The prescribed rate is given under section 115A, that is 20% plus surcharge plus education cess. Now next, the following income should be deemed to accrue or arise in India if the royalty is payable by a person who is a resident. Who is paying the amount? A person who is a resident in India. Now, person is defined under section 2 subsection 31 of the Income Tax Act. Who is a person? Person includes individual, HUF, Hindu Undivided Family, firm including LLP, limited liability partnership, company, association of person, body of individual, local authority, artificial juridical person. So a person, any of these 7 people who is a resident in India, if they are paying royalty to a non-resident person, then in that case he has to deduct TDS. But friends, there are 2 exceptions to this rule. That is, when a resident is making royalty payment to a non-resident, except where the royalty is payable in respect of any right, property, or information used or services utilized for the purposes of a business or profession carried on by such person outside India. If that person is carrying on business outside India or for purpose of making or earning any income from a source outside India, then in that case tax is not deductible on royalty. Let's take an example. Mr. X is a resident of India. He has taken some trademark from a non-resident outside India, and he used that trademark outside India only and sold some goods out of it. As the income arises outside India from the business and profession which is carried out outside India, suppose in Singapore, therefore in that case the income gets taxable in Singapore and it does not get taxable in India because the business or profession is carried on outside India. The business or profession is not carried out in India or for the purpose of making of or earning any income from any source outside India. These are the two exceptions which are very important. Yes. So, no, the payment is only the payment criteria is not being seen. We have to see other aspects as well. We will see the case law in which it is being said that manufacturing activity per se does not denotes that amount of royalty is taxable in India. Here the payment is made from India. A resident is making payment to a non-resident. But in that case we have to see whether the source is located outside India. Suppose the source of income is located outside India or business or profession is carried outside India. In that case it would not be taxable in India. So here he is making payment outside India. The amount is not received by the non-resident in India. To 206AA, there are certain exceptions. Suppose he will show tax identification number and complies with certain conditions, then in that case 206AA will not be applicable. Yes. In that case, if he is showing you another documents like there is a TRC tax identification number, so on that basis, and he is filing form 10F, so he can avail the benefit of lower rate. For example, I have given right to use a brand name in India and I have to pay royalty. Example, at the rate of 5% of my turnover, and I made sale in India. On sale, income tax department will ask me whether you are a resident in India or you are a non-resident in India or you are a government. So first I will say I am not a government, I am a resident in India. Then the question which arises is whether this person is resident or non-resident. So my company is resident and covered by 916B. For brand name, you are making payment. You have to withhold tax. I am paying royalty for a business set up by me, but carrying out business outside India or profession outside India by me, that does not qualify as taxable. A big firm engaged me and shared its brand name. I can use the brand name. I opened my business or service in India. I opened another office in Singapore. Certain businesses in India such as outside India, as in I have a branch in India in Singapore, 100 crore turnover overall, 5% royalty which comes to 5 crore rupees. So it is being divided, India getting 3.5 crores, Singapore 1.5 crores. So the Singapore related payment will not be covered as royalty in India. Then the second exception, which says that a person who is a non-resident is making payment to a non-resident for royalty. So if a non-resident is making payment to a non-resident for royalty, how government will come to know that it is taxable or it is not taxable? Government is getting database in the form of AIS, annual information statement, where they can come to know that whether the income deemed to accrue or arise in India or not. So a non-resident means a Singapore company has made payment to a US based company. In that case, tax is deductible if it is in the form of royalty, and where the royalty is payable in respect of any right, property or information used or services utilized for the purpose of business or profession carried on by such person in India, or for the purpose of making or any income or source in India. So if a non-resident is earning any royalty income in India, that will become taxable in India. There should be a direct connection between the income which is run by the non-resident. Now further moving, there are certain exceptions which I was saying. In the case of BHEL, BHEL company, High Court stated that export, if you are doing export sales, it is not treated as royalty and nothing would be taxable because it is being done outside India, export is made outside India, therefore the income is generated outside India. It was being held by the Madras court in the case of BHEL. But if we will see the Havells India Limited decision, Havells India Limited decision says that manufacturing of goods has been done in India and then it has been exported from India. It should be said that the source of income and not the receipt of it should be situated outside India. Therefore, in Havells Limited case, it was held that if there is export also, so we have to see whether the customer is outside India, whether use of the product is outside India, whether payment is being received from outside India, whether goods are exported outside India. So in the case of Havells, there is an adverse judgment. Court said that those exported income would also be treated as income earned in India and it gets taxable in India. So for a similar matter, we have two judgments where one court is making a favorable judgment while another court is making an unfavorable judgment. Then there is a concept which comes export commission. Whenever an export commission is being paid, whether it will be treated as a royalty? No. Export commission is generally a normal commission. It is a business income, if we can say, or it is not covered under royalty. If it is a business income, then we have to check whether permanent establishment is in India or not. Then we have next case of Lufthansa Cargo India Private Limited. What they did is they have given aircraft on lease basis. They sent their aircraft abroad. This is in regard to fees for technical services. Aircraft sent outside India and they have done the repairs of aircraft outside India, and now aircraft has came back to India. Now they are making payment for their repair and maintenance done outside India. The question arises whether the source of income is situated in India or outside India. In the cargo case, Delhi tribunal said source of income is located outside India. where the repairs and maintenance took place. Hence, it cannot be taxed in India, and therefore benefit of exception given in section 916 and 7 is available to the SSE, and there is no need to withhold tax under section 195 in the present case. It is a correct judgment because the repairing and maintenance has been done outside India and has not been linked with India. Next, we have a Bangalore Tribunal's judgment in case of Titan Industries Limited. Friends, we all are aware that Titan Industries is very famous and engaged in manufacturing and selling of watches. They make beautiful watches. They are manufacturing watches and selling their watches. They have associated company, that is related company in Singapore. Singapore entity promoting sales of Titan watches in Asia Pacific region, and for which they have got patent for their brand name in Hong Kong. So brand name is in Hong Kong and company is situated in Singapore, and they are making payment for this royalty to Singapore entity. Now what happened is Titan India is making royalty payment to Singapore entity for all the sales made in Singapore. The source is outside India, and Bangalore Tribunal held yes, the SSE saying is correct. This is deemed to be the source located outside India. Therefore, royalty paid by Indian company to Singapore company is not taxable in India. Merely having manufacturing in India does not make the source of income in India. This is a very important judgment. Further, we will take an example of Apple. Apple iPhone. Apple USA asked contract manufacturer in India to manufacture Apple laptops and iPhones, and they sold all over Asia Pacific region. Apart from manufacturing, more aspects to be seen whether it qualifies for source situated in India. What happened in this case? Contract is executed outside India. Merely manufacturing does not qualify to be a source in India. This is a personal view. So here there are chances of difference of opinion. Next, section 9 of the Income Tax Act. What we have seen till now, section 9(1) subsection 6 says, if Indian government is making payment to a non-resident of royalty, in every case tax is required to be deducted. There are no conditions being mentioned. Second, if a resident in India is making payment of royalty to a non-resident, all cases are covered except where the royalty is payable in respect of any right, property or information used or services utilized for the purpose of business or profession carried on by such person outside India, or for purpose of making or earning any income from any source outside India. Then, if the payer is a non-resident in India, the royalty income will be taxable only where the royalty is payable in respect of any right, property or information used or services utilized for the purpose of business or profession carried on by such person in India, or for the purpose of earning any income in India. Now friends, there was an explanation 1 which says that before 1st for 1976 agreement, then it is not relevant now. Therefore, we are not covering explanation 1 to section 916. Now, explanation 2 to subsection 916. What it says? It is very interesting. Royalty means a consideration, including a lump sum consideration other than consideration chargeable under the head capital gains. If the patent, trademark or any other intellectual property is being sold and capital gain arises on that case, it would not get taxable in 916. We have to look into the capital gain provisions for the same. What we are considering right now is royalties, which includes lump sum consideration as well. Now royalty is from what? From the transfer of all or any rights. What we are doing? We are transferring all rights of our patent, trademark, copyright, know-how to the licensee in respect of what? Patent, invention, any invention made. Suppose vaccine. We all have faced the pandemic. So a vaccine is being made, an invention is made. That invention, either right is being given to India to make more vaccines. So either that right was being sold, or either they have given right to use that invention. Then some model is being designed. Suppose car model is there. Then some designing is being done. There are different artistic work being designed. There is a secret formula. Example, aircraft. There is a secret formula behind making of aircraft. So if they have shared that secret formula, or there is a process or trademark, we have done a trademark, suppose Nike or any other Adidas, many branded models are there, or any similar property. So friends, this is basic, like these things are being covered in the definition of royalty. These are not explained. Patent is nowhere explained in law. Invention is nowhere explained. Model, design, secret formula, process or trademark, similar property, nowhere explained. What we have to refer is the explanations which are given under the 916 as well as the general laws. As our court says that if there is no specific definition given, then we have to apply the general principles, that are the general laws which are prevalent in the society. Then next is the imparting of any information concerning the work of or use of. What we are using is use of patent, invention, model, design, secret formula or process or trademark or any similar property. The use of patent, invention, model, design, secret formula or process or the similar property. Now, if a person receives any consideration and the person is a non-resident, and from whom he is receiving either from the government, he is receiving either from the resident, or if he is receiving it from the non-resident, in that case it becomes taxable. Now further explanation 2 says the imparting of any information concerning, it must be related to technical knowledge, it must be related to industrial knowledge, commercial knowledge, it must be related to knowledge, experience or skill. But the use or right to use any industrial, commercial or scientific instrument, but not including the amount referred to in 44 BB. Section 44 BB specifically covers some activities done by non-resident and it gets covered over there. Friends, in last slide we have seen patent. Now what is patent? We have to look at the Patent Act. If I did patent in my name, ICO, Indian company, example made Max vaccine, and vaccine patent is being done by them in the patent law of India on US patent law or in US patent law. Given formula to Indian company, they said that we will take 20% of royalty of all the sale of vaccine, we will charge that. So patented medicine for vaccine, this cell you can made only within India. The condition they have imposed that the vaccination should be sold in India only. The transfer they have made with a restriction that you can use it only in India. So we have to see the patent as per patent law. Second, invention. If I made a new tool, I invented a new machine, new fuel engine. I have invented something new, and that new is being used by somebody, and any payment is made to me for the invention. It is known as royalty. Third, model. New model design. Suppose new iPhone. I have designed a new iPhone for Apple. I have designed a new laptop for Dell. Dell has commercially used the laptop and paid any consideration. That is being termed as royalty. Then next, secret formula. Something which is secret, which is not being said to anybody. You made any secret formula. How to make anything like dam, bridge, and there is a secret formula for the same, and you make payment for the same. That is being termed as royalty. Next is process. What is the process? Process is a step-by-step thing. If there is a process undertaken by a person, by following this process, a product is manufactured or can be done, then in that case, you are making payment for the process. This payment is for royalty. Example, we have to make a road. For making a road, there is a process. We cannot just make a road by having some cement or some material with us and a simple road is being made. There is a process being involved in it. Person is giving some know-how to you for this. You are making payment for that. Then next is trademark. Reebok, Nike, Levi's, all having trademark. These people are having trademark. They have given franchisee to us. They have sold or they have given right of their brand. We are using the name Levi's, Reebok, Nike, etc. They gave their brand to us. They are not running outlets. They have just given the franchisee. Whenever you are using trademark, you are covered under the trademark or brand name. It is covered in trademark definition and you are liable to deduct tax on payment of this royalty. Second point, the person has not transferred the rights, but the person has imparted the information. He said that I will give you information about my product, but I will not transfer you the right to use it, considering the working of use of patent. Then third is, there is no transfer, no information, but given for use. You can use patent, trademark, license, etc. He gave the patent, trademark, etc. You can use it as per your convenience. We are not selling it to you, but we are giving a right to you. Example, Mercedes car given for use in India. You can commercially exploit this particular patent, this design model, etc. This use is also being defined as royalty. On this use, we have big controversy whether use of software is used. It is use of secret formula, may be regarded as a process, and in some cases may be regarded as a trademark also. Friends, software thing has came. Software is a very big issue and we have a separate session on software for the same. Then if you transfer anything, that also gets covered. The transfer of all or any rights, including granting of license in respect of any copyright, literary, artistic or scientific work, including films or video tapes for use in connection with television or tapes for use in connection with radio broadcasting. So here the transfer of any of these things are being covered. Example, you have shown foreign movie in India. Previously there was a clause that but not including consideration for sale, distribution or exhibition of cinematographic films. But now this clause is being removed. Therefore, cinematographic film, if being shown in India related to foreign movies, it will get taxable if any royalty is being paid on the same. Actually, this rule of cinematographic came for the film of Gandhiji. Wherever Gandhiji's film is being shown, it was not taxable. But later our lawmakers have changed it and they have made it taxable. If foreign films released in India broadcast on TV, then it will be deemed to be royalty and taxable in India. Films were first excluded from royalty, but now these films are included in royalty. Then, sixth, rendering. This is very important clause. Rendering of any services in connection with the activities referred to in 1 to 4, 4a and 5. So, whatever services or activities are given, they get covered as a royalty. We do not have given any of the above things, but someone has provided services in respect of above clauses. For example, US company appointed me as a sole selling agent in Delhi NCR. No consideration other than consideration paid, no royalty. But if they granted right, for granting this right, they are charging me 10 lakh per annum. So that would be classified as royalty and tax is being charged on the same. Then friends, we have two explanation is in regard to computer software given under section 916. First explanation is explanation 3, which says computer software means software program recorded on any disk, tape, perforated media, that is a separate media, or other information storage device, and includes any such program or any customized electronic data. There was so much confusion about computer software. Therefore, they separately gave in the explanation that computer software means this. Then explanation 4 of 916, it is clarified that the transfer of all or any right in respect of any right, property or information includes and has always included transfer of all or any right for use or right to use a computer software, including granting of the license, irrespective of the medium through which the right is transferred. Example, in CD or pen drive downloadable version, if there is any right in regard to computer software, we will deem it as a transfer. Deeming fiction will apply. Computer software right, explanation 2 clause 1 covered, explanation 4 read with explanation 3. As per domestic law, any domestic software, any kind of right to use that software, including granting of license, is deemed to be royalty. Then we move to explanation 5. Explanation 5 to section 916. Now what it says, it is clarified that the royalty includes and has always included consideration in respect of any right, property or information, whether or not the possession or control of such right, property or information is with the payer. Now these clauses are very important. Now whether you possess that right or not, it does not matter. But if you are using that right, then the taxation liability will arise on you. Second, such right, property or information is used directly by the payer. This is very important that payer should use it. Third, where the location of right, property or information is in India, the location must be in India. We will see there is a case law of Asia Satellite, Delhi High Court judgment. What they said is, right to use must have possession or control. Not necessary. It is not necessary that there should be right to use, possession or control. Pair have used equipment, trademark or copyright, it also does not matter. It must at least be in India does not matter. Therefore, to overrule the above judgment, explanation 5 has been added so that satellite and bandwidth charges are being covered and royalty is being imposed on the same. Then we have explanation 6 to section 916. It defines the process. Process is very important word in concept of royalty. Transfer of all or any rights in respect of the process. It is clarified that the expression process includes and shall be deemed to have always included transmission by way of satellite, including uplinking, amplification, conversion for downlinking of any signal. It includes cable, high seas cable, optic fiber, or by any other similar technology, whether or not such process is secret or not. So we have Asia satellite and bandwidth case. We do not own the equipment. We do not have possession of the equipment. These equipments are underlying cables. These are high seas cables. These are not located in India. There is no secret process. It is same for all telecommunication or satellite companies. Hence, there is no secret formula in this. And for considering this point, section explanation 6 has been added. It has been covered in the process definition. So explanation 5 says we have definition of royalty, definition of computer software, definition of process, but possession is not important in any of the above cases. Now, most important aspect of royalty is know-how. Know-how is related with knowledge. It is not defined anywhere in the Act. So we have taken the definition from ANBPPI. ANBPPI is a Belgium group of AIPPI which is actively involved in international activities. So what they are saying, know-how is all kind of undisclosed technical information, whether capable of being patented or not, that is necessary for the industrial reproduction of a product or process directly and under the same condition, in as much as it is derived from experience. Know-how represents what a manufacturer cannot know from examination of the product and mere knowledge of the process or technique. Let us have an example. How to assemble this mobile. We have an iPhone mobile. How we can assemble it? So we have a screen of mobile. We have battery of mobile. We have other components with me. So now how to assemble this so it will function properly and being classified as a mobile. Generally there is a specific process for it. It means it has a know-how in this. So we have to take know-how from the company who has made the process of how to assemble the mobile instrument. If it means it has know-how in this, so somebody is making payment to get the knowledge about this know-how, or some kind of rights are being transferred through this know-how. Otherwise it cannot be classified as royalty. Some rights in know-how is to be transferred. One more example, how to drive a car. Car is a normal car. Anybody can do it and run the car. There is no know-how in it. How to learn a car, anybody can learn it. It does not involve any know-how element in it. I can go to Maruti car showroom and ask them that I want to learn a car. They will tell me. I don't have to pay for know-how. I just have to pay a fees of around 3000 or something, and they will allow me how to run a car. Then somebody is telling you how to run a plane or how to run a particular machine manufacturing cycle which is not commonly known by people. A plane, it's not very easy, anybody can operate a plane or aircraft. So in this case, know-how is being involved. So when a know-how is being involved in a complicated thing, then royalty is being paid, and on that royalty tax is to be deducted. Now there is a very important concept, that is referral fee. Like friends, we are chartered accountants or advocates. We refer some matters to each other. Suppose I do not have some knowledge in any subject, therefore I referred it to you. Now you paid me a referral fee. So whether referral fee given is treated as a royalty. So for this, we saw the OECD model. Someone paid referral fee, and against this there is no information which is imparted by the person. Referral fees is something which is a commission to introduce the client, and referral fee is being given. Whether there is any secret formula behind referral fee, whether there is any know-how, whether there is any other formula, whether it is covered under royalty definition, whether any brand name is used, no friends. Referral fees cannot be regarded as royalty. We cannot deduct any tax in case of referral fees. Now, we were saying that royalty is being charged for giving the use or right to use of any instrument. But what is use or what is right to use? Friends, this expression use is not defined in the Act. We have no definition under the Income Tax Act. Hope maybe it will come in the new Income Tax Code, as well as Article 12 of Model Convention. It is also not defined under Model Convention. But what it says is, it includes leasing, letting or licensing. If we will refer to Oxford Dictionary, it defines use as meaning exploit for one's own end, employ for some purpose, apply to one's own purpose, the act so employing, using or putting into service. Leasing, letting or licensing, whether it will be treated as use. Example, a car is being given or a cycle is given. So I gave it to my friend. So he charged me rent on it. He said, I will charge 1000 rupees if you will give me your car to run it for 7 days. So whether 7000 paid to be deemed to be a royalty, what Ola, Uber, taxi, they all are charging charges from us. Whether it will be treated as royalty. Suppose if it would be treated as royalty, then either under domestic law 194J would be applicable or 195 would be applicable and tax to be deducted. So therefore friends, it does not classify under royalty and no tax is to be deducted. Then what is the meaning of word use? We referred Oxford Dictionary definition. It is not necessary that the use is being regular. Suppose I have taken car on rent for 7 days, but I have not used it. I have put to use. I have a right to use. Then it would be classified as that entitlement is being given to me. It means a grant, whether exercised or not. It is on me, which signifies as a grant or being exercised. If I got right and used it, it is termed as use. Use is very important. I got right but not used. Example, car taken for use but not used. You have right to use also. Whether you enjoyed the right or not does not enjoy the right. Either consideration is paid for using scientific equipment, consideration paid for right to use is defined as royalty. What court says that in one of the judgment, it was held that the word use in relation to equipment occurring in clause 4A of explanation 2 through section 916 is not to be understood in a broad sense for availing the benefit of equipment. There must be some positive act of utilization, application, or employment of the equipment. Then it is right to use. Customer must operate or control the equipment in some manner and exercises certain degree of right or control. Example, if possession is of car not given, then it is not at all used. Without possession, there would be no royalty. What is important is control and possession. Control and possession must be there. Then either merely renting and leasing. Example, I have to move from Delhi to Mumbai. I purchased a ticket. I used the aircraft. What I got right to sit on a seat. A part seat is being given to me. It is not at all a royalty. But somebody got possession of the aircraft. Suppose Mukesh Ambani ji. He got possession of the aircraft. He has complete possession and he alone took it on rent and lease and he paid amount for the same. It will be termed as royalty. Then friends, this is all about Income Tax Act, where royalty has been defined or not defined, or certain clauses has been given or not given. Now we are moving to Article 12 subsection 1. Article 12(1). There is no section or subsection under DTAA. DTAA is an agreement for the purpose of avoiding double taxation. How we should eliminate double taxation? From Vienna Convention, DTAA came into force. Taxpayer should not be charged tax on the same income twice. That's why DTAA has came. Now in DTAA, we have two methods so that your income should not be taxed twice. First is exemption method. Exemption method covers one of the country will not tax you. Another country will tax. Means resident country has right to tax you, but the source country will not tax you. Second method is a credit method. Credit method, both the countries will tax you, but from where the royalty income is originating or any income is generating, we have to see. So source state as well as resident state, both are going to tax you. Now both has taxed you, but the resident state will give you foreign tax credit. Foreign tax credit is a separate subject and there is another session for the same. Now the total double tax agreement is based on two models, OECD model and UN model. Third is unique, that is US model. US is a developed country. US is a main player. Therefore, it says that I must have my own model and I will make my own treaty. Some are based we cannot see like Australia or Singapore. There are 90 treaties which are signed by India with other countries, and we have multilateral instrument as well as some are covered in covered tax agreements, but some are not covered. So per se in a session we cannot take every treaty. Therefore what I have tried to cover is that what OECD model says, what UN model says and what US model says. We will have this type of languages in our treaties whenever you will see the treaties. Now developing countries uses UN model. India is a developing country. It uses UN model. Countries which are developed, they use OECD model. They consider OECD model. Maximum treaties are based on UN model. Other treaties are based on OECD and US model. India has one treaty signed with US, and in that case US model applies. and in another cases UN model applies. OECD model is basically treaty for developed countries. When developed countries make treaties, they follow OECD model. UN model is organization where developed and developing both are there. India is a developing country following UN model. Developed nation may start with OECD negotiation. Treaty negotiator negotiation skills. These models are defined. Now Article 12(1). What it says, why we are reading treaty. Our Income Tax Act state royalty is taxable under section 916 of the act. Prescribed rate is 115A and TDS under section 195. However, 90 and 90A defines if there is any benefit which has been prescribed in these treaties, then this treaty law will override the Income Tax Act. IT Act 10% rate and DTAA 5%. Then treaty law will prevail. There is a difference. The Income Tax Act must include surcharge and education cess separately. So our rate becomes 20.8 or 22. But the treaty rates are inclusive of surcharge and cess. We can bifurcate with Income Tax Act. Article 12 generally deals with topic of royalty. Article 12(1) OECD model. What it says, royalty arising in a contracting state. Let's say the contracting state is India and beneficially owned by a resident of other contracting state, that is Singapore, shall be taxable only in the other state. What it says is that it is taxable in Singapore. Example, India-Singapore Treaty, OECD model, royalty arising in India and Singapore, beneficially owned by Singapore, it is taxable in Singapore only. Taxing right is given to Singapore. Therefore, it is an exclusive right of taxation given to Singapore. This type of methodology is known as exclusion or exemption method. Source has no right to tax it. Only resident country has a right to tax it. This is an exclusion and exemption method in OECD model. Then next, many countries feel that their brand will go outside, like Marks and Spencer brand is from London. So many countries feel that their brands will go outside. Therefore, OECD model gives taxing right to resident state only. Second is US model. US model defines royalty arising in India. I am substituting the word contracting state to India, and beneficially owned by a resident of other contracting state, that is Sri Lanka, shall be taxable only in that other contracting state, that is US. Exclusive right is given with US. It is same like OECD model. The resident country has right to tax. 12(1) in OECD and US are exactly same. Third is UN model, United Nations model. Royalty arising in contracting state India and paid to a resident of other contracting state UK may be taxed in the other state, that is UK. Now it is also same as OECD and US, but there is a proviso in articles, that is UN model. However, just like proviso, it is an exception. Such royalties may be taxed in the contracting state in which they arise. It means the right is being given to source state as well. They gave right to source state also, and according to the laws of that state, which is beneficial owner of the royalties is a resident of other contracting state, the tax so charged shall not exceed 1% of the gross amount of royalty. 1%, 10%, 20%. So they have a limited clause that you cannot charge royalty of more than 10 or 20%. The competent authorities of contracting state shall by mutual agreement settle the mode of application of this limitation. They have to settle the rate, that is tax rates negotiated by the company. What India have with other country treaties have 10% clause. Maximum percent is 10%. On treaty law there is no surcharge or education cess. There is a treaty between India and Singapore. A company in US having branch office in Singapore, he is not the beneficial owner. Now friends, beneficial owner concept is very important. Tax is levied on beneficial owner country only. Suppose there is a paper company in between. So that paper company would not charge taxation because that paper company does not have tax in their country. So tax will be levied in India maximum 20% and balance tax would be levied by Singapore. This is being given in the UN model. If it is beneficial owner in Singapore, third state is the beneficial owner. We have to go to country where beneficial owner is situated. When royalty is going to tax havens, we don't apply treaty which is receiving amount, but we levy between India and the beneficial owner. Example, paper company opened and we made payment from India to paper company, but it will go to beneficial owner in Singapore. Whether they are real beneficial owner, whether they are owning the brand or know-how or technology, if beneficial owner is someone else, then treaty between them is denied. Maybe, shall be, may only be, shall only be are interchangeably text words used in treaties. This gives exclusive rights to jurisdiction. Maybe, may only be, shall only be, interchangeably words only being used, shall be interpreted by courts as exclusive provision. It shall be taxed in residence country, then source cannot tax it, only resident country can tax it. Only in cases where the word used is may be taxed is termed as shall be taxed. Income tax department has PLIA, may be taxed gives rights to both the contracting states. There is exclusive right which is given to one contracting state, one particular country. Intention of treaty negotiation shall be taxed, shall only be taxed, may only be taxed. Now, point Article 12, Sub-Article 2. Now, the definition of royalty is given in OECD, US and UN model. OECD model, the term royalties as used in this article means payment of any kind received as a consideration for the use of or the right to use any copyright, literary, artistic or scientific work including cinematographic films, any patent, trademark, model, design, plan, secret formula or process, or for information concerning industrial, commercial or scientific experience. There is difference in 916 and OECD model. What is the difference? It says, but use of or right to use of industrial, commercial or scientific instrument. 916 says that if we use or we have right to use of industrial, commercial or scientific equipment, it will be classified as royalty, but the same is not given under OECD model. Rendering of services in relation to above is also missing in OECD model. These two differences are there as compared to 916 and OECD model. Computer software is not mentioned in the OECD model. If something is not royalty, then what it will be? Then it will be business profit. And that business profit is covered under Article 7 of the treaty, and it will be taxable only if there is a permanent establishment in India. Generally, they do not have permanent establishment under domestic law. Mostly everything is covered. OECD model definition is restricted. It's very small. OECD has not defined royalty definition properly. Then US definition of royalty. What United States says. The term royalty as used in this article is payment of any kind received as consideration for use of or right to use any copyright, literary, artistic, scientific or other work including cinematographic. Our definition does not cover cinematographic films now, but US definition covers it. Any patent, trademark, design, model, model, a plan, secret formula or process, or for information concerning industrial, commercial or scientific experience. It's same as OECD, only last line difference. Then UN model. They define royalty as used in this article means payment of any kind received or as a consideration for use of or the right to use any copyright or literary, artistic or scientific work including cinematographic films or television broadcasting, any patent, trademark, design or model, plan, secret formula or process for the use of or right to use industrial, commercial or scientific equipment or for information concerning industrial, commercial or scientific experience. There are tapes which are being used for broadcasting. This is specifically included in the definition of royalty itself. If you are using any scientific or industrial equipment, it is termed as royalty. UN model is broader in terms of definition. Equipment used is also treated as royalty. Now, we have to analyze these definitions which are being given. UN model already having equipment leasing as a part of royalty. Even OECD has used to have their equipment, scientific equipment leasing as a part of royalty, but in 1992 they have removed it and UN edited this part in 2017, and in 2017 model of UN this leasing income of scientific equipment is part of the model, and both the documentary says if something is not covered under the definition of royalty, something is not taxable under Article 12 of the Convention, then the income goes to Article 7, which is business profit, taxable only in the case of permanent establishment situated in source state. This is how these models work on royalty definition. If it is an exemption method, so in case of OECD model or US model, any kind of royalty arising from India is not taxable, but India unfortunately does not have treaty like that. But if India have any treaty like this, then this royalty goes tax free in India. Nothing will be taxable in India. But now let us come to third part, which is treaty is based on UN model. Now we say use of equipment or right to use the equipment is termed as royalty. Then also we have to see certain additional facts which is not there in the domestic law or which have been override by way of amendment in the domestic law. Example, I hired as an Indian resident, I hired an equipment might be scientific industrial which is covered under definition of domestic law taxes, that is royalty. That is explanation given under 916, explanation 3, 4, 5 and 6 is not applicable under definition given under treaty law. So explanation 3 to 6 not applicable. Still we need to answer these 5 questions. Now for analysis we have to ask ourselves before applying Article 12, there are these 5 questions which we have to ask. Who is in physical possession and control of equipment and royalty? Physical control and possession is not in the same state. The pair of it cannot be treated as royalty. Example, I hired construction equipment. The company sent its employees to run that equipment. He does the work. As per domestic law, it will be treated as royalty, as it is the use of scientific equipment. But when we go to treaty law does not cover it and it does not tax it. Whether Indian pair has possession of equipment or not, no, then it is not covered under treaty law. The answer is yes, then no problem. Then second point is who has significant economic or possessory interest in the property. My interest is limited to the higher charges of equipment, but the significant economic right and interest lies with the owner of the equipment itself. So then this test also fails. Now third point is, who bears the risk of substantially diminished receipts or substantially increased expenditure if there is no performance under the contract? If the equipment does not work, then who is liable to bear the risk? That question we have to ask. Fourth, who uses the property or equipment currently to provide significant services to entities unrelated to service recipient? Whether equipment is used as a part of service to be provided to the payer, or it is only the equipment which is used as a service itself. If only the equipment which is given, then only it is classified as royalty. But if the equipment is given as a part of combo services, then it is not regarded as royalty. Then fifth test is, total payment for the service does not substantially exceed the rental value of computer equipment for contract period. The computer equipment example, the value of equipment is rupees 1 lakh and I have charged rental value amounting to 2 lakhs. Then what is this? This is merely renting and it is not royalty. If I charge only 5,000 rupees to this, then yes, it is treated as royalty. So depend on the facts of the case, we have to test royalty or leasing of instrument on 5 grounds which we have seen. 5 grounds which we can say whether it amounts to royalty or not. It does not deal with royalty, leasing or right to instrument. Definition in treaty law is very narrower and Income Tax Act is very wide. If DTAA is beneficial, then DTAA will apply. Friend, this is all about allocation of rights between the states, between the countries. Here the state means countries. So what different models says is that they mainly emphasize on resident. If you are resident of any country, then you are eligible to charge royalty income. You are eligible to charge taxation on the royalty income. But UN, United Nations model, has taken a liberty. They said that both the source state as well as resident state, they can charge taxation on royalty basis. So this is all about the royalty and the allocation part of it. Thank you so much for the opportunity.